So today we're going to talk about Article 44. Now this article becomes very relevant given the current condition and given the current situation, because this article talks about what is generally known as Uniform Civil Code, right? UCC, which we are hearing a lot these days about. Now, this provision is contained, as we know, in DPSPs, the Directive Principles of State Policy. So this article gives a directive to the state that the state should endeavor to secure to the citizens a uniform civil code. It talks about securing to citizens a uniform civil code. Of course, it talks about doing it in the territory of India, but for us, this is important. Now, when we talk about uniform civil code, we have various ideas about it. But let us try and understand how this concept has evolved over the years. But before we do that, let us understand what is uniform and what is civil and what is this code, right? So the word uniform is very simple to understand because it means that something is common and same for all, right? Right? So it is uniform to all. Now, let's talk about the word civil. Now, this word civil is not really defined, in a positive sense, but it is generally defined in a negative sense, meaning that civil is something that's not criminal, right? But for our context, in the context of the Uniform Civil Code, this civil basically means the matters that relate to people's personal lives, which is personal matters, right? Personal matters of civil nature. Now, what are those personal matters of civil nature? These personal matters of civil nature would generally include such as marriage. Another important element within that or related to it is divorce. Very important issue that comes up is maintenance, right? Maintenance that's to be given to the wife after divorce. Adoption, who can adopt a child, and there are rules that decide. Very important is succession. Now, the succession inheritance also forms this Uniform Civil Code, right? Now, these things are actually governed by, for most of the communities in India, their personal laws. Now, what are these personal laws? So these personal laws basically have generally a religious background to them. They come from the religious texts. They're not really codified at one place to be called personal laws, but they are found in various religious texts of various religions, right? And from there, certain aspects are picked up, and then they start governing various aspects of these matters of life of people. In Indian context, this issue of having a uniform civil code or having personal laws that cover these aspects of life, uniform or uniformly applicable to all the people living in the country, irrespective of their religion, has been an issue which has been pending for long, and it has been a contentious issue, primarily because in India we have almost all religions, major religions being followed by the people here. And then we have had a long history of tensions or some sort of conflict prevailing between various religious groups on this issue of application of a uniform civil code to all. So there is some background to the Uniform Civil Code. The first notable effort in this direction was made by Dr. Ambedkar way back in 1947, when he introduced the Hindu Code Bill in 1947. Now, in 1947, the Constituent Assembly was in the process of making the constitution, but as you know, that it also had legislative powers and acted as an interim parliament. So this bill was introduced as a bill before the parliament, that interim parliament. Now, this bill is one of the longest debated bills in the Constituent Assembly or that interim parliament. And the debates went on for more than 4 years. And finally, in 1951, October, this bill was rejected and it could not be passed. And Dr. Ambedkar was so disappointed for this failure to be able to have this Hindu Code bill made into an act that he resigned from the cabinet, saying that this was an important issue. And what was contained in the Hindu Code bill, so the Hindu Code bill applied to not the people who profess Hindu as a religion alone. It applied to other religions also. And the definition of this word Hindu here was very wide. This Hindu here included, of course, those who professed Hinduism or call themselves Hindus as a religion. But it also included Buddhists, it included Jains, it included Sikhs as well, right? Which meant that this bill was trying to bring uniformity in the laws govern these aspects of the people belonging to these religions in India, right? It, of course, excluded. These were included. What was excluded? The exclusion was the Muslims, the Christians, Jews, Parsis. They were not part of this code. Why was that? Maybe we will have to understand that. Let us first understand what did this bill try to do. No, it was trying basically to bring equality, particularly gender equality in all these matters governing marriage, divorce, maintenance, adoption, or even succession, inheritance. It was also trying to protect women, children, old age people, their interests with regards to, of course, these matters, such as it proposed to make divorce legal. It gave equal rights to women in the property of father. It also gave equal rights to women in terms of adoption. Now, this act finally could not be passed, but in the early 1950s, some laws were passed governing different aspects. The provisions which were there in the Hindu Code bill were incorporated in those specific laws governing specific aspects, such as we have Hindu Marriage Act, 1955, for example, or we have Hindu Succession Act. Then we also had Special Marriage Act. Now, these are the acts which incorporated most of the features of equality and protection of interests of women, particularly, that were there in the Hindu Code bill. This, of course, brought some sort of uniformity in matters of marriage, divorce, maintenance, and adoption and succession, as far as these people are concerned. However, we would see that Muslims and Christians, they continue to be governed by their respective personal laws. For example, Muslims were being governed at that point, and even today to some extent, by something called application of Shariat Act. This was an act that was brought in by the British, which made the application of Shariat as a personal law to govern these aspects for the Muslims. Christians do not have such a personal codified law covering all aspects, but Christians were governed by Indian Christian Marriage Act. That was very old act of 1872. Now, Jews and Parsis and Christians together then were also governed by Indian Succession Act of 1925. Now, if you see, there were so many laws, different laws, which were applicable to different religions. Today also, if you see, whereas these laws are for the Hindus, and of course the word Hindu includes Buddhists, Sikhs, and Jain in that definition. We have a special marriage act which is applicable for all as far as marriage is concerned. But at the same time, we have a Muslim personal law in place. We have a Christian marriage, Indian Christian Marriage Act, or also which governs the Christians. With this multitude of laws governing various aspects of the personal life of people, the need to have a uniform civil code is really well placed, and logically thinking, it is something that we should have. However, let's understand what are the problems with having such a code and why it has taken so long for the country to have a uniform civil code, despite the fact that this mandate was given in the Constitution itself, right from the beginning, in Article 44, as a directive principle of state policy. Let us see what has happened during last 7 odd decades after independence in this context. And let us also try and see how things got more and more complicated by certain events and things that happened in the past. Let us go to 1985, where we have a very, very important Supreme Court judgment, which is popularly known as Shah Bano case. Now, in this case, the Supreme Court said that the Muslim women have right to seek maintenance under a secular law, which is CRPC, Section 125 of CRPC, which provides for maintenance of wives, parents, old age parents, and children as well also, and said that the Muslim women can be given maintenance under CRPC Section 125. Now, this was welcomed by many, but at the same time, there were some orthodox element among Muslims who opposed it, and there was an uproar on this issue. And the then government, the central government, in 1986, the very next year, came up with something called Muslim Women Protection of Rights on Divorce. And in this act, in Section 3 of this act, a provision was made that the Muslim women will have right to receive maintenance during the period of iddat from a husband. However, beyond the period of iddat, now let's first understand what this period of iddat is. This period of iddat, in this particular context, is a period of wait, before which a Muslim woman cannot marry after divorce. So if divorce happens today, then from this day, for 3 months, the Muslim woman who has been divorced cannot remarry. And hence this period of 3 months would become a period of iddat. After this period, she is free to remarry. And the husband is supposed to give maintenance to his divorced wife only during this period of 3 months. This is the period of iddat. This act also made a provision that after the period of iddat, the responsibility of maintaining or providing for maintenance of the divorced woman or her children would be on the relatives of the woman who are to inherit her property. And if they fail to do so, then it goes on to the Waqf board, which meant that beyond the period of iddat, if the Muslim woman doesn't remarry, then she's simply left without any security whatsoever, because she has to then depend entirely on her relatives for support. And that situation prevailed for a long time, despite the fact that we had this Shah Bano judgment very clearly stating that the protection or for maintenance on divorce is available to Muslim women under Section 125. But because of this specific act governing the specific aspect of divorced Muslim women, resulted in some sort of confusion, and the courts after that giving varying and sometimes contradictory orders, judgments, sometimes going by this understanding that even if there is this law in place, the secular law applies. But on the other hand, there were some other courts which said that there is a specific law governing the rights of divorced Muslim women, and hence that specific law will have precedence over a general law, which is a common understanding. Now, this situation prevailed for close to about 15 years, when in 2001 we have another Supreme Court judgment, very important Supreme Court judgment in the matter of Daniel Latif. Now, this Daniel Latif case is important because it restated once more. Now, this Daniel Latif case is important because it upheld this law passed in 1986, right? Because this law was under challenge. So what did it do? It upheld the law. Which law? This law we talk. The Muslim Women Protection of Rights on Divorce Act, right? With these provisions. But while upholding this law and the said provision, it said one more thing which is important for us. It said that even though there is a specific provision, the Muslim women still have a right to seek maintenance under CRPC. You know, Muslim women can seek maintenance under Section 125 of CRPC. Now, this brought in some sort of clarity because the court was of the opinion that the legislature, the parliament, cannot have an intention of passing an unconstitutional law, and that the law which has been passed by the parliament is not inconsistent with the provisions of CRPC or any other provisions of governing about equality enshrined in the Constitution. After this, there was more clarity, and generally the courts were allowing applications of divorced Muslim women under Section 125 of CRPC. But there was still a little bit of confusion, and particularly the parties which were losing these cases, the men folks who were parties to such cases of maintenance, they kept going to the higher courts again and again on the ground that there is a specific law governing this aspect of Muslim women, and in the presence of a specific law, general law does not apply. Was again answered, and answered more emphatically, I must say, in the matter that we have seen, 2024, this very year. In the month of July, the Supreme Court gave another judgment. Now, this judgment is very significant because the court, in a way, gave a very positive definition or positive interpretation of a non-obstante clause which is contained in that personal act. What is that? The Supreme Court said, let us understand this. The Supreme Court said that the Muslim Women Protection on Divorce Act and its Section 3, which provides for maintenance during the period of iddat, says that notwithstanding anything contained in any other law, in existence. This will apply. Now, this non-obstantive clause of notwithstanding anything contained in any other law, how do you interpret it? Normally, whenever you have this non-obstantive clause, notwithstanding anything contained in any other law, is generally taken to mean that the provisions of this law, which contains this non-obstantive clause, will apply over any previous law or any other law that exists. However, if you go by the literal meaning of the word notwithstanding, it actually means at the same time, whatever may be the case there, this will hold true. It does not really mean that all other laws will die or will stop to be in operation. However, generally speaking, the notwithstanding and these non-obstantive clauses like this were being taken to mean that these laws or these provisions which contained or began with such non-obstantive laws have a superseding effect on other laws. So the Supreme Court came up with what I call a coexistential interpretation of a non-obstantive clause. What does it mean? It says that whenever there is if there is a non-obstantive clause, something like notwithstanding anything contained in any other law in force, would mean that this provision and the provisions in other laws can coexist, which is what finally the Supreme Court said and declared in a way that Muslim women can seek maintenance under the secular law which is available to all the people under Section 125 of CRPC. The court also went on to say that the women are free to choose, free to invoke any of these provisions, whatever is more beneficial for them. Now, what is interesting is that this particular observation of the Supreme Court, that the personal law, if you may call it so, the personal law given here in Muslim Women Protection of Rights on Divorce Act and CRPC provision, if they can coexist, and which is what the court finally said, gives us a hint of a possibility. If it can be applied, if this principle of coexistence of such secular and personal law at the same time, and making people and giving people a choice to choose between the personal or the secular law, whatever is beneficial to them, gives us a hint to a possibility of having a uniform civil code. See, because the uniform civil code is likely to have a lot of opposition from some elements. In a diverse country like India, with so many religions coexisting, it is a welcome idea to have uniform laws governing all these personal matters, which bring about gender equality, which protect the interests of women, children, the old age people, which also seek to bring about some sort of national integration by way of having uniformity in these matters. And there cannot be, I believe, much argument against not having a uniform civil code. However, this question of having a uniform civil code or not having it is not really that simple. For example, if you ask me whether I'm in favor of the uniform civil code that is being proposed currently, then I will not be in a position to answer it in yes or no. Whether I'm in favor of of course, in principle, favor of having a uniform civil code. However, my answer to this question, whether I am in favor of a uniform civil code being proposed, would not be yes or no. It would be that we first need to see what are the contents of this uniform civil code. What does it contain? Because it is all about what it contains that one will have to form an opinion whether it is something to have or not. I must also mention that there is a sense of doubt in the minds of people, particularly coming from religious minorities about what is there in this uniform civil code that is being proposed. So it is very important for the government to try to be more consultative in their approach. Of course, we've seen that the Prime Minister has reiterated his party's or the government's ambition to have a uniform civil code in the 78th Independence Day celebration on the Red Fort, which means that the government is, of course, willing to bring about uniform civil code. But it would do much better if it does so in a consultative manner. They should, instead of talking about it, without sharing details, they should actually come up with a draft. That draft should be put in public domain. They should try to engage with the opposition parties as well, and the civil society and public at large, and try and build some sort of confidence and consensus on the contents of the uniform civil code. And by that way, I believe it would be possible for the government to have a uniform civil code that will be taken positively and accepted by various religious communities living in India. And trying to force the matter will not help. That is what is something that I worry about. There have been instances in the past with this very government where they have pushed through very important legislations without any notice or without any discussion or debate in the parliament. If the government resorts to something like that, in case of uniform civil code, I believe that's going to have disastrous consequences and might lead to more tensions, more conflicts, more heartburning, in various sections of the society. So we hope that these all steps that I talked about will be taken by the government, and we might have a uniform civil code governing all religions, all citizens living in India, bringing about that equality, the gender equality in personal matters, bringing about a sense of unity in the country.